North Dakota has one of the least regulated breaking lease frameworks in the country, consistent with the state's overall minimalist approach to landlord-tenant regulation and strong property rights orientation. The governing law is found in North Dakota Century Code, Chapter 47, Tier 16, which covers landlord and tenant relations, along with general contract principles. If you're a landlord or tenant in North Dakota, the limited statutory framework means the lease agreement is your most important document when a tenant needs to leave early. Let's start with the landlord's duty to mitigate damages. North Dakota recognizes the landlord's duty to mitigate through common law principles and general contract law. When a tenant breaks a lease and vacates, the landlord must make reasonable efforts to re-rent the unit. The landlord cannot simply leave the unit empty and hold the departing tenant liable for the full remaining rent without making any effort to find a replacement. The landlord must take reasonable steps: advertising, showing the property, and accepting qualified applicants. What constitutes reasonable depends on the circumstances, the local market conditions, the property's condition and location, and the landlord's typical practices. The landlord is not required to lower the rent or accept an unqualified applicant, but must make the same effort they would make to fill any other vacancy. If the landlord re-rents, the departing tenant's liability is limited to rent during the vacancy period, plus reasonable re-rental costs. If the landlord fails to make reasonable efforts, the departing tenant's liability is reduced accordingly. North Dakota courts evaluate mitigation reasonableness on a case-by-case basis. Early termination clauses are generally enforceable in North Dakota. The state does not have a specific statute capping early termination fees or restricting how leases handle early departure. North Dakota's contract law principles govern, and the state generally enforces negotiated contractual provisions. A clause requiring 30 to 60 days notice and a fee of 1 to 2 months' rent is typical and enforceable. North Dakota courts will enforce early termination fees that represent a reasonable pre-estimate of anticipated damages. A fee that is grossly disproportionate to actual damages could be challenged as an unenforceable penalty. But North Dakota's legal culture gives significant deference to private contract terms. Military members have the right to break a lease under the Federal Service Members Civil Relief Act. Active duty service members with qualifying orders can terminate by providing written notice and a copy of the orders. The lease terminates 30 days after the next rent due date. No early termination fee or penalty applies. North Dakota's military population is centered around Grand Forks Air Force Base and Minot Air Force Base, both significant installations that generate regular SCRA lease terminations. Grand Forks AFB houses unmanned aerial vehicle operations and generates steady rental demand. Minot AFB, home to both bomber and missile wings, generates significant demand in the Minot area. SCRA lease terminations are a regular occurrence in both Grand Forks and Minot. Military assignment cycles at these bases typically run 2 to 4 years, and the regular rotation of personnel creates predictable lease break patterns. Landlords in both communities should have standardized SCRA processes: verify orders, accept notice, calculate the termination date, waive all fees, and process the deposit return within the statutory time frame. North Dakota does not have a specific state statute providing enhanced lease-breaking protections for victims of domestic violence. Unlike states that have enacted dedicated provisions allowing domestic violence victims to terminate a lease early with documentation, North Dakota has not enacted such a provision. Domestic violence victims who need to break a lease must rely on general contract principles, negotiate with the landlord, or seek assistance through advocacy organizations like the North Dakota Council on Abused Women's Services. This gap is notable, and landlords can address it voluntarily by including a domestic violence early termination clause in their leases. Allowing termination with 30 days' notice and a copy of a protection order protects vulnerable tenants and reduces the risk of a tenant fleeing without notice. Tenants in North Dakota may break a lease if the landlord fails to maintain habitable conditions. Under North Dakota Century Code Section 47:16-13(1), the landlord has a duty to maintain the premises in a fit and habitable condition, including compliance with applicable building and housing codes and maintenance of essential systems. If the landlord fails to address serious habitability issues after receiving proper written notice, the tenant has remedies that can include lease termination. The tenant must provide written notice, identifying the deficiency, and allow the landlord a reasonable time to make repairs. If the landlord fails to act within a reasonable period, the tenant may terminate the lease. North Dakota's extreme climate creates specific habitability issues that can trigger lease termination rights. Heating system failures during winter, when temperatures can reach 40 or 50 below zero, constitute genuine emergencies that require immediate response. A landlord who fails to restore heat within hours, not days, during a North Dakota winter faces potential liability for damages and gives the tenant strong grounds for immediate termination. Pipe freezing, roof ice dams, and snow load structural issues are additional winter-specific concerns. North Dakota also recognizes constructive eviction. If the landlord's failure to maintain the property or affirmative actions, shutting off heat in winter, failing to address dangerous structural issues, changing locks, make the unit uninhabitable, the tenant can treat the lease as terminated. Given North Dakota's climate, conditions that might be inconvenient in a temperate state can be genuinely life-threatening in North Dakota, and courts evaluate constructive eviction claims with this context. North Dakota has provisions regarding abandonment. If a tenant abandons the property, leaves without notice, removes belongings, and stops paying rent, the landlord can retake possession. The landlord should document evidence of abandonment before entering: unpaid rent, absence from the property, removed personal belongings, disconnected utilities. The departing tenant remains liable for damages subject to the mitigation duty. North Dakota's eviction process is relatively fast. The state allows just 3 days' notice for non-payment of rent. This fast timeline means landlords can quickly regain possession when a tenant stops paying as part of breaking the lease, reducing the vacancy exposure. The Bakken Oil region creates unique breaking lease dynamics in western North Dakota. The boom and bust cycle of oil and gas drilling has created dramatic fluctuations in rental demand and correspondingly dramatic fluctuations in lease break frequency. During boom periods, when oil prices are high and drilling is active, workers flood into Williston, Watford City, Dickinson, and surrounding communities. Rents skyrocket and housing is scarce. When prices drop and drilling slows, workers leave en masse, breaking leases as they go. Landlords in the Bakken experienced waves of lease breaks during the 2015-2016 price downturn, and again during the 2020 pandemic-related collapse. The financial consequences of broken leases in the Bakken are magnified by the market dynamics. During a downturn, the departing tenant's liability may be significant because the landlord cannot re-rent quickly. The same market conditions that cause the tenant to leave also mean there are fewer replacement tenants available. During a boom, broken leases are less costly because replacement tenants are readily available. Landlords in the Bakken should structure their leases to account for this volatility. Shorter lease terms, 6 months rather than 12, reduce the exposure for both parties. Clear early termination provisions with defined fees give workers a mechanism for departing when their assignment ends. And maintaining financial reserves during boom periods provides a cushion for the inevitable downturn. From a practical standpoint, North Dakota's rental market is small and concentrated in a few population centers. Fargo is the state's largest and most stable rental market. The economy is driven by healthcare, education, North Dakota State University, technology, agriculture services, and manufacturing. Fargo's market is moderate with steady demand. When a tenant breaks a lease in Fargo, the landlord can typically re-rent within a reasonable time frame, perhaps 2 to 4 weeks for a well-maintained unit. NDSU's enrollment creates seasonal student demand. Lease breaks timed to the academic calendar are easier to fill. The Fargo-Moorhead Metro straddles the North Dakota-Minnesota border. Properties on the Minnesota side are subject to Minnesota's significantly more restrictive landlord-tenant laws, including stronger mitigation requirements and broader tenant protections. Landlords operating on both sides of the metro need to understand the different frameworks. Bismarck, the state capital, has a stable market driven by state government, healthcare, and energy industry administration. Re-rental times are moderate. Grand Forks, home to UND and Grand Forks AFB, has a market influenced by both the university and the military. Military lease breaks from the base are routine, and the university creates seasonal student demand. Minot, home to Minot AFB, has a market heavily influenced by the military. The base's personnel rotations create constant turnover, and landlords in Minot should expect and plan for regular SCRA terminations. BAH rates for Minot drive pricing, and the military population represents a dominant portion of the market. Williston, Watford City, and Dickinson in the Bakken region have markets that fluctuate with energy prices, as discussed above. These communities require a different lease structuring approach than stable markets like Fargo or Bismarck. One best practice for North Dakota landlords include a clear early termination clause in your lease. Given the state's limited statutory framework, the lease is your primary governing document. Specify the notice period, the fee amount, how the security deposit will be handled, and the condition the unit must be returned in. A well-drafted clause provides certainty for both parties and reduces disputes. Another best practice, document your mitigation efforts whenever a tenant breaks a lease. Even though North Dakota's mitigation framework is based on common law rather than a detailed statute, the obligation exists. Keep records of listing dates, advertising platforms, inquiry counts, showings, and when you accepted a replacement tenant. This documentation establishes the departing tenant's liability and proves you acted reasonably. A third best practice, for landlords in Grand Forks and Minot who handle regular military lease breaks, build SCRA terminations into your business projections. If a significant percentage of your tenants are military with 2 to 4 year assignments, you can predict how many SCRA terminations you'll process annually. Planning for this turnover, maintaining efficient make-ready processes, having a marketing pipeline always running, and processing SCRA terminations quickly minimizes vacancy and keeps your operations efficient. North Dakota requires landlords to return the security deposit within 30 days of the tenant vacating. The deposit must be held in a federally insured interest-bearing savings or passbook account. There is no statutory cap on the deposit amount. If the landlord fails to provide an itemized statement of deductions within 30 days, the landlord may forfeit the right to retain any portion. These rules apply whether the departure is a normal move-out or a broken lease. For the complete guide to North Dakota breaking lease laws, visit tenantscreeningbackgroundcheck.com. Subscribe to our channel for every state in our Breaking Lease Law series.